Next.
So,
Lord,
document
in
number
this
two,
matter,
I
matter
have
has been fixed for filing
This
written
is
notice of
open
argument.
argument. This
My
is
lord,
my lord.
I have
An argument
little
on
some
top of
time,
that.
my lord. This is my application, my lord.
Yes.
But I have little some time, your lordship.
Lord, I am submitting my
Lordship.
written notes and argument
the
on behalf of the
opposite
opposite
party.
parties.
The
Yes, my lord.
written notes of argument filed by the uh,
Lordship, this has come up at my instance, your lordship, for clarification of the order. देखिए, order टा कोई- Clarification of the order dated 1st September 2025.
yes, what
Your
clarification
lordship
you want?
kindly comes to the second last page of the order,
Yes.
paragraph 28, your lordship.
Yes.
There your lordship has directed the petitioner to pay 20,000 as cost to the Union of India, your lordship.
Yes.
Now the difficulty, your lordship, I'm ready with the check and everything. I have even written a letter to the executive engineer of Union of India CPWD, but they have refused to accept the letter as well as
But
the check.
where is Mr. Trivedi? Please,
I have asked, inquired from him as well. He was also unable to
please ask him to come
at 12 o'clock, your lordship.
at 12.
All
Ask him
right.
to come at
All right. Grateful, your lordship.
Yes, call the next matter. Yes.
Pursuant to my lord's direction, my lord, I have served, my lord.
Yes. Who is appearing?
My lord, delivery report, track report says my lord, article has been delivered upon the opposite party.
When? Eighth of September.
Yes, my lord. This is the learned commissioner's report, my lord, filed.
No one has entered appearance in the website. Now it's available if someone enters appearance.
Not yet.
Where is the commissioner's report? Every service filed in court today is taken on record. In spite of service, one opposite party or many opposite parties?
The plaintiff opposite party, other as the
One.
one. Like each is the plaintiff.
What is the suit for?
Suit for partition.
Partition, why one?
The other, my sisters has been added as a defendant along with myself. The elder brother filed the partition suit against me as well as the other sisters. In the specific, kindly comes to the plain, page 11.
But Mr. Ghosh, in a suit for partition, all are necessary parties. Who have served only upon the
No, the injunction, the injunction against me, not others. I started construction in the Khosirul property.
Every service filed in court today is Yes. Yes.
Municipal matter, my lord, the lordship on the other occasion were directed to file the copy of the proceedings, my lord. That has been filed on the last of.
Yes. Where is the petitioner?
I do not know where.
Now the petitioner has fled away.
Private respondent here. Mr. Shankar Vishwas was there for the private respondents.
There is a private respondent.
His junior is here, my lord. He's
So then I am vacating the interim order. There was an interim order.
yes, yes.
None appears for the petitioner at the time of call. 227
It is likely to be.
Yes, next.
Another writ petition also pending, my lord. I am also filing another writ petition again,
I've not done it, I have only discussed.
my lord.
So,
That I appear for the opposite.
learned senior counsel, Mr. Basu is engaged in another court. So,
Mr. Basu is very busy just before
so
the.
may I pray for short
Yes,
Basu,
yes.
others.
Yes,
Short Basu.
That I appear for the opposite party, the municipality is here.
yes. All right, pass over.
Passover.
Yes,
Any time mentioned?
when 12,
That 18,
yes.
18.
I appear for the opposite party.
You are for the petitioner. Who is for the petitioner?
I appear for the extension of interim order.
The interim order, it is subsisting or it has expired?
Already expired.
A very short
Please,
matter.
please,
It may
please.
be taken up. The interim order is not subsisting.
You have filed an application for extension. Can 2,
Can one.
can 1. What is can 2?
Can two, my lord, one of the opposite party has died intestate.
The opposite party has died
One of the opposite party has died. Her legal heir is on record.
on record.
Already on record.
So I'm allowing that application. This application, who died?
The opposite party number 3, Deepali Chakraborty.
Where have you stated? Which paragraph? Dipali Chakraborty. Three. Heirs are
Heir,
opposite party 1 and 2. No,
husband.
only 2. Acha. Can 2 tate aage. This can 2 of 2025.
আমরা বসে আছি না বসে আমি তো বসে আছি
And দুটোই disposed of. Yes.
Very, very short matter, my lord.
Yes, yes.
My lord, the defendant
This
is
is the
the
extension of interim order.
My lord, the matter can be placed, my lord, the
application-
very, very short matter, my
Yes,
lord.
yes. This,
My lord, defendant is the petitioner, my lord, suit for declaration was filed.
this matter has appeared under the
My lord,
heading
I am
extension of,
appearing for the opposite.
under the heading
My lord,
extension of
kindly
interim order. Motions are there.
My lord, so far as
All matters then has to
my
be
lord,
taken.
kindly place it after the vacation
It will be
immediately, my
taken
lord.
up after the vacation. Please
My
mention.
lord, kindly consider because my client has been suffering.
But a joint prayer, my
My
lord,
lord,
can take up after
kindly
the.
take it.
So only 6-7 days left before the vacation.
No, so far as this is
So come
concerned,
after
my
the
lord,
vacation, I will consider that. Please come after the vacation. Yes. Yes. Who is appearing?
Item number 13, my lord, I am appearing on behalf of the petitioner. Extension.
You have filed an application for extension.
Application, my lord.
Can one?
Can one, my lord.
Can one of 2025?
Item number 14, my lord, I appear.
Any extension, 3 times extended, right? It will be extended until further order. That will be directed.
Until further orders.
I keep it, sir.
You want until further orders?
My lord, up to a date and until further order. The same thing, same thing, extension.
আচ্ছা, ঠিক আছে, বুঝতে পারছি, ঠিক আছে।
To a further date.
Another appearance.
Yes, yes.
My lord, previously, my lord, we have filed an CAN 1 application seeking extension of the earlier interim order.
Yes.
Thereafter, we have not filed any application, but
Uh,
this has been served upon the parties, my lord, opposite parties.
The learned advocate appearing for the petitioner submits that the notice has been duly served upon the opposite party.
Petitioner.
Yes.
Extension of interim order.
Extension. Have you served?
Yes, last occasion I have filed affidavit
Uh,
of service, my lord.
None appears to oppose the prayer for extension of interim order. First of the interim.
They filed a suit for declaration.
After hearing, have you served, Mr. Mukherjee? Every service filed in court today is taken on record. Mr. Mukherjee, learned advocate appearing for the petitioner submits that the opposite parties have been duly served. In spite of service, none appears to oppose the prayer for interim order. To step in view thereof, the interim order is extended till the end of the month of
December.
May. It has expired,
Sir,
Mr.
file was not traceable. Kindly remember, my lord, this matter, file was not traceable. Lordship directed the matter to appear, my lord, in the monthly list. Kindly see.
Till the end, till the disposal of the civil division application.
Kindly limited.
Yes, it's still the
File
disposal.
limited. Kindly limited. But suit for eviction analogous trial is required, my lord. Limited period, my lord.
February 2026. Yes. Every service taken on record. Yes. Next.
17, my lord, I am for the petitioner suit for eviction, my lord. I am the plaintiff. PW 1 cross-examination was closed. Thereafter, they have filed a order.
You have served.
Yes, sir.
Every service filed in
I am
court today is taken.
appearing.
Number 18, my lord, I am for the petitioner led by Mr. Calcutta Basu. He is appearing, my lord, virtually. May I file the evidence of service, my lord?
It's a hotly contested matter.
No, my lord,
What no?
there's
Don't say no. Yes, after hearing,
there's one clarification. Milord, the interlocutory applications, Milord, they have been heard, but the learned judge is not disposing them of because of this order of stay. Can you
Mr.
direct
Chatterjee, what is the law?
in the law is, Milord, that he can, but he isn't. Lordship clarifies it. There is
Why?
no-
Mr. Chatterjee, where is the necessity for clarification?
Milord, if he-
Law says so.
he is
If
not
the
bound
law
to
says so,
judgment on the
you
ground.
have to apprise the learned trial judge of that.
Milord, can he, I am apprising through your Lordship.
No, no, no.
Can
You have to
Milord,
do
tell that
something
the
there.
interlocutory applications may be disposed.
Mr. Chatterjee, it will go a wrong signal, Mr. Chatterjee.
Milord, it gives the right signal that the court is directing, Milord, the law to be followed. Nothing beyond that.
Yeah, so what,
Only
Mr.
mention-
Chatterjee, so you act in accordance with law. That
No.
is what here.
Applications may be disposed of.
Yes, so
Thank you,
I will,
Mr.
please please act in accordance with law.
He directs the interlocutory applications to be disposed of. This does not go into the state. Milord, with respect to the main matter, Milord,
Yes, Mr. Mukherjee, you are for the petitioner.
But I, for the petition, but I have a very short point to argue.
No, I
before your
can,
lordship.
Mr. Mukherjee, it's not
But your
possible now.
lordship has
to-
already recorded in my lord's order, my lord, my point of argument.
No,
But if
uh,
your
that
lordship
is-
desires
that-
to hear it after the vacation,
Milord, it's a
your
short
lordship
one.
can do.
Right,
So I am
Your Lordship,
extending
this-
that only Mr.
this-
Chatterjee says some interlocutory applications,
But
those have been heard, but the orders are not being passed.
let him just specify which
Injunction application filed by them.
Injunction application filed by you.
I have to take instruction.
So, Mr. Mukherjee, they say that the hearing is concluded.
My application, my lord, I can wait after the vacation. Mr. Chatterjee.
He says, Mr. Chatterjee,
Doubt whether the application has been totally heard or not.
No, it's heard.
So, my lord, your lordship finds, my lord, that.
Mr. Chatterjee, now it's there's a difference of opinion. Mr. Mukherjee says,
Doesn't get
both
into it.
Mr. Mukherjee
Milord,
does not.
doesn't- Lordship need
If
not
that
get
is so,
into it.
Mr. Chatterjee, if that is so, please apprise
I
the
think
honest
my
trial.
application I can
Because
wait.
that there is no impediment in disposing of the pending interlocutory
This
application.
should be added.
Good.
That's it. It doesn't prejudice anybody. Number
Uh,
one. Milord, number two, there's one more prayer. The revision application
application
is basically on the ground, Milord, that the commissioner could not be, Milord, cross-examined because he is dead. This is the only point before your lordship. Milord, I have 3 judgments for your lordship, Milord, to consider. This is the only point which
I will
is
consider,
required.
Mr. Chatterjee, I will consider
very
it
good.
after the vacation, please.
Just after the vacation, kindly fixes a date.
So if you want, I can extend it till the end of the month of December.
Your lordship extends it
keeping-
whenever your lordship wants.
It's
but-
under the heading motion, Mr. Chatterjee.
Yes, Milord. Lordship,
It's appearing in the
Lordship,
list.
yes, Lord.
It's appearing in the list. I am
And I also have a vacating application. So whichever way, my lord, just after the vacation, kindly fix it.
after hearing the learned advocates for the respective parties, the interim order is extended. সবাইকার নামগুলো দিয়ে দেবেন।
One.
The interim order is extended till the end. আবার virtually-ও আছে।
Mr. Kollol Bose is
Yes, yes.
on our side.
He has become a virtual lawyer now.
No,
He must be sitting somewhere in the blood.
he becomes a virtual lawyer only when he has to do something in court. When he has to, my lord, give a lecture somewhere, he is there physically.
Is extended till the end of the month of December 2025 or until further orders, whichever is earlier. Let the matter retain its petition in the list under the heading motion. It is appearing under the heading
Yes,
motion.
yes, motion. I'm grateful.
No,
Yes.
that clarification.
Clarification, Mr. Chatterjee,
That
there is a
I have to
dispute.
take instruction
They say
Lord, because
that whether
I say
you
that
applies,
if it is my application, Lord, I've got no rush.
Acha, Ashun. Mr.
I've got
Chatterjee,
no
I'm a
rush.
senior advocate appearing for the
Opposite party number 1.
opposite party number 1 submits that the injunction application filed by the petitioner
Petition.
before the learned trial judge has already been heard and pays for a direction upon the learned trial judge has already been heard, but on account of pendency of the civil revision application, no order is passed thereupon. So such submission is seriously opposed by the
Petition.
disputed by the petitioner and is seriously disputed by the learned senior advocates appearing for the petitioner and the opposite party number 3. So stop, it will be open to
2 and 3.
3. It will be open to the opposite party number 1 to make appropriate submissions before the learned trial judge in this regard.
There is no
Lordship.
impediment in disposing it.
Mr.
It is my application. I do not know why Mr. Chatterjee is saying and not he says that it is to be disposed of. I need to take an instruction on it.
Yes.
If it
take
is my
instruction,
application, then I must
But
be
Mr.
having a right.
Mukherjee, with regard to this, interlocutory applications cannot be stayed.
But first of all, I need to know whether it is pending or not.
Yes.
Look, there's nothing transpiring from the orders.
There is no
There's nothing from
impediment.
the orders that your lordship will find that that is not pending.
So I have only recorded his submission and both of you can take steps.
But we come up just after the vacation, my lord, and
Yes, call the next matter.
I'm grateful. My lord.
Any application was filed there? No.
Yes, sir, here. So we did.
Their application for vacation.
But that is not appearing in the list.
Can one be
Can one is the vacating application.
can one is appearing? I am told. My lord.
Can one is appearing along with the main
I
matter
am told. My lord, Mr. Mukherjee.
under the heading motion. মোশনে কি ক্যানটা সঙ্গেই রয়েছে সেটা
মোশনে
দেখে নিন
দেখাচ্ছে?
Can.
Yes, yes. Can one or two? 20?
Yes, yes. Yes, show the next matter.
My lord, I beg to appeal for the opposite party, my lord.
My lord, this is my lord, my revisional application. My lord, there was an interim order passed on 18 June 2025, my lord, which is subsisting till my lord, the last day of this month.
My lord, I am opposing the prayer of the extension of the interim order. But my lord, if my lord come to the order dated 18 June passed by my lord has rightly observed that after going through the plaint of the two suits, the court is of the prima facie view that both the suit are to be heard analogously. So my lord, this is an application filed by my learned friend.
After hearing the learned advocates for the respective parties, the interim order is extended till the end of the month of February 2026 or until further orders, whichever is earlier. The matter under the heading contested application after 12 weeks.
My lord, service.
Every service.
Grateful.
My lord, one thing, my lord, the next date on the before the learned court is fixed on 8 November, my lord. My lord, kindly fix a date prior to that, my lord.
Yes, call the next matter.
But I am appearing for the petitioner.
Yes.
My lord was pleased to pass the interim order till end of September 2025. My lord, it
Who
was
is appearing for the other side?
I have served. On the first occasion, they entered
And
into appearance. Still, then my lord directed to serve the copy of the application upon
The
the
learned
parties.
advocate for the petitioner, none appears to oppose the prayer.
It appeared as a contest application in the month of December.
It will appear after 12 weeks. Yes, next.
My lord, I am for the petitioner, my lord. My lord, the interim order is till the end of the September, my lord.
Have you served?
Yes, my lord, I have served, my lord. They have received all the, my lord.
Every service filed in court today is taken on
For the petitioner, this is my application for expeditious disposal.
of what?
I have prayed for suit as well all the applications, connected applications.
What are the applications which are pending?
Yes, Lordship, one repairing application and order 39 rule 7 application.
And order 6 rule 17 disposed of.
Disposed of, Lordship.
So order 39 rule 7 and the repairing application.
Repairing application,
What is
Lordship,
the next date fixed? 18th of November.
18th of November,
This
Lordship.
application under Article 227 of the Constitution of India is at the who are you?
I'm
On behalf of the petitioner,
Defendant plaintiff, I'm praying for
Defendant plaintiff,
defendant.
respondent.
Defendant.
defendant opposite party, yes.
Praying for not this week, my lord, because just I received yesterday the brief, my lord.
Yes, let me see.
There is one caveat, so we have sub the caveat.
Yes, she's appearing for the caveat. Yes, what is the,
The simple matter is that, my lord, there is rejection of order 6 rule 17 for modification of the application of order 7 rule 2 order section 7(2) of the West Bengal Presidency Act. What happens, my lord? There are certain facts was not pleaded in that applications. It's very simple. It's amendment of very simple in nature. Our contention is that we didn't receive any summons after searching.
where is the application for amendment?
Applications, my lord, in page number 21, my lord.
Page number 21.
Only the incorporations in the pleading regarding the knowledge of the case. This is suit for eviction. And the schedule of amendment is page number 24. As because, my lord, the matter was running in the ex parte, we appeared. That was on the we appeared on 19th May 2022, and we filed on 25th. Sorry, no, sorry, my lord. Knowledge was gathered 25th April 2022. We appeared on the very next day, 26/4/2022, with an applications for out of ex parte board, and we filed the 7172 on 19th May 2022, when the date was fixed, within 1 month from my knowledge. That's to be incorporated in 72 applications. It's very normal, very normal. And we have filed our WS also in the month of 19th November 2022 with along with cost. They have accepted the cost.
Yes, what do you say?
1 week time, kindly, I'm not prepared.
1 week, why?
Yes, my lord, just yesterday I will receive the brief, my lord, and I don't know.
I have served on 12th.
And I filed the Bukalatnama.
By the order impugned, the application for amendment
I am for the petitioner. Other first beware of the petitioner for expeditious disposal of injunction application.
Injunction application.
Injunction application.
This application under
That petition. Malad passed on 6th September 2021. And statute is saying malad within 1 year it should dispose of malad.
this application under Article 227 of the Constitution of India. Twenty-five years. None appears for the petitioner at the time of call. No accommodation has.
Your Lordship, Mr. Shonak Bhattacharya is appearing for the petition, Your Lordship. Mr. Shonak Bhattacharya.
Since I'm not inclined to take up
At 27, I think for not today on behalf of Mr. Partha Pratim Roy. He is engaged in another court, my lord.
He was a busy counsel just before the vacation. Please start. Please start. Yes.
This is that, my lord, the preemption case was filed by the petitioner. The consideration amount was 4,50,000 and what? And I have filed the preemption application.
You are the preemptor.
Yes, my lord.
Yes.
With the amount of one.
Preemption application dismissed.
Yes. Subsequently, my lord, the appeal was filed. The preemption application was dismissed on the ground the entire share was transferred. But when I have preferred the appeal was dismissed on the ground that I have not deposited the consideration amount.
Valid ground. This application under Article 220. Obliged, your lordship. Yes.
29, my lord, I am appearing on behalf of the petitioner, my lord. This revisional application is for, my lord, for early disposal of the application under Order 39, Rule 1 and 2. Of,
Who are you?
My lord, I am the preemptor, my lord. My lord,
Preemptor?
yes, my lord. Preemption application was filed by the petitioner, my lord.
Article 227 of
My lord, kindly consider, my lord. My lord,
Very difficult.
September 2023, my lord, the application file. If your lordship kindly specify that.
as expeditiously as possible.
Declaration and for partition and for permanent injunction, I am the defendant. My lord, injunction order was granted. My lord, I appeared. I challenged the title of the plaintiffs. My lord, in the suit, my lord, plaintiff has filed a 151 application. I am for police help. My lord, I agreed only second part of the second portion of the order dated. My lord, kindly see the ordering portion second part. My lord, starting with B. It is necessary. My lord, got it. But B, it is necessary to mention herein that OC Indus PS is directed to look into the matter that plaintiff can also be allowed to cultivate the land as proportionate to their share. So share has not been till declared. But how the police will
Why? Police cannot decide.
But I challenge his share. Police will decide the share and allow him to cultivate. I am agreed by the only second part, my lord. Impugned 30 impugned order date.
I've said impugned order date 30th of June 2025.
Yes.
তাই বলেছি তো। Yes, next.
My lord, I am for the petition.
Same police.
My lord, I am in a suit for title. I am the defendant number 1. Defendant number 2. My lord, defendant number 6 expired. My lord, plaintiff brought into the record by way.
What is the order under challenge?
My lord, last order, my lord, last first 1/7/2020, order number 20, lordship, last page of the certified
Order
copy.
number 20.
Last page.
Yes.
Only 2 points, my lord, allow me. First, still lordship, after
Abatement not set aside.
yes, abatement not.
Show me the application. Show me the application for substitution.
Yes, lordship. Substitution application is at page. But page 23 is the substitution.
You are the defendant.
I am the defendant.
Which defendant?
Defendant number 2.
Defendant number 2. And defendant number 6 died.
Died.
What is the relation between defendant number 2 and 6?
Family members.
Family members. So did you
No,
comply with?
family, my lord, I am correcting myself. Not family members. They are all different.
Order 22 Rule 10 capital A complied with?
No, my lord. My lord,
That is a valid ground for
my lord,
setting aside.
then my lord, he should at least should state that where he has not able to put the application within time. That has not been pleaded also.
So Order 22 Rule 10 A not complied with. That's a valid ground for substitution after setting aside abatement. Where is the recent decision? Following 2003-10 SCC. What is the suit for?
Suit for declaration and for cancellation of deed.
Rejected.
This application under article.
Well, the PW cross examination of the PW1 is going on.
You are PW1.
Yes.
This application under article 220.
Because the matter of transfer from the Barasat to Howrah.
The learned advocate appearing for the yes.
Well, 33 is an revisional application arising out of section 19 of the Hindu Adoption and Maintenance Act, where the claim of the widow of maintenance from the father-in-law has been turned down. Lordship, there is no appeal provision. So this will be in effect the first appeal. So my request will be if Lordship kindly calls for all the lower court records, because the evidence, it has been decided.
Nowadays, the lower court records, you can produce the evidence.
This is finally disposed of. Finally disposed of.
Yes.
So
All don't have the copy of the evidence.
no, my lord, this is an indigent person. I'm through legal aid services. So all copies could not be obtained. The only ground on which it has been rejected,
You serve first, let me see.
it has been served. It has been
Served.
served. There was a caveat.
Who is appearing for the caveat here?
Mr. Porichoy Pathok.
So I'm posting it after the vacation.
Lordship,
Contested
kindly
application.
post. I'll serve again. And some preference may be given. Some preference may be given because absolute destitute condition, indigent person.
It's a hearing matter, Mr. Mukherjee.
In the meantime, Lordship kindly calls for the LCR. Let
Uh,
that come. Because there was no interim maintenance, I will not
Take
get
up, there is no provision for appeal.
There is no provision for appeal in that.
This application under article by the judgment and order impugned, the miscellaneous case filed under section 19,
Section 19 of Hindu
the Hindu Adoption and Maintenance Act, to dismissed. First up, Mr. Mukherjee, learned advocate appearing for the petitioner submits that the learned advocate for the caveator has been duly served. First up, affidavit of service filed in court today is taken.
I am filing in the course of the day.
আচ্ছা, leave দিয়ে দিন তাহলে. Leave is granted to the learned advocate on record of the petition.
Obliged, my lord.
Yes,
But before your lordship, Mr. Bhattacharya is appearing.
since I'm not inclined to take up this.
My lord, I am for the petitioner, my lord. This application has been filed, my lord, against the order passed by the, in misappeal, my lord. What happened, the opposite party number 1 filed a suit only for.
Misappeal injunction.
My lord. My lord, what happened, my lord? The opposite party number 1 has filed a title suit for mandatory injunction and refuse, and the injunction order, ad interim injunction order was refused, my lord, at this stage. That is at page 52. and that is on suppression of material fact, my lord. The petitioner herein is the absolute owner, my lord. The record of right and my lord deed has been annexed at page A, my lord, annexure A. And my lord, he is claiming that there is an unauthorized construction and the undivided property. But my lord,
You have entered appearance in the appeal.
my lord, I have
So I'm directing the miscellaneous appeal. Look, this is against an ad interim order of injunction. I'm directing the miscellaneous appeal to be
my
disposed
lord,
of
now there is a charge court, my lord. The second court, my lord, is the charge court, my lord, may be directed.
because I
upon-
cannot stay the order of injunction at the admission stage. So it's better you enter appearance. What is the next date fixed?
My lord,
Why you did not appear? This order was passed in April. You are directed to appear in May.
my lord, thereafter, my lord, he is appeared, my lord.
He has appeared.
My lord.
When he appeared?
16/6.
16/6.
My lord,
And
16 and filed the written objection, my lord.
where is the caveator? Have you served upon the caveator?
My lord, I am not the caveator. my lord. The opposite party number 1 is the appellant, my lord.
What is the number of the suit? 359 of 2025.
My lord, that is my suit, my lord. For the
Yes. So caveat has been lodged there, but not against miscellaneous appeal.
my lord, that is another suit filed by the petitioner. That 359, my lord, that is filed by the petitioner.
That is the other suit.
My lord.
Your suit is 254.
My suit is 359. And the
caveat is against 359, sir.
My lord, I am playing, my lord, the title suit filed by the opposite party number 1, that is 254. And against that, my lord, Miss appeal has been filed.
So miscellaneous appeal is against the suit filed by the opposite party.
My lord. My lord, they have filed because the injunction.
When you appeared and entered appearance
on 16/6, my lord, I have.
What is the date fixed in the miscellaneous appeal?
My lord, on my lord, 8 December, my lord.
Records have arrived.
My lord. That is on 11/6, my lord.
By the order impugned, the learned judge of the appellate court, the learned additional district judge, first court at Barakpur, passed an ad interim order of injunction. Now, by the order impugned na kore the learned additional district judge, by an order dated 23rd of April 2025, passed an ad interim order of injunction, which was extended by the subsequent orders dated
4/6/2025
and 1st of September 2025. Full stop.
My lord.
After hearing the learned advocate for the petitioner and upon That's yes, yes, Mr. Trivedi. ওইটাই তো নাকি? Two না three? Three. Yes, Mr. Trivedi.
Milord,
Why are you not accepting the cost?
Milord, it is not accepting. What happens, Milord?
Which
Because
department?
though Union of India has been made a party, but the specific department is Department of CPW.
No, executive, it has been addressed. কোথায় তোমার ওটা?
We are getting the exact department address, Milord. We will supply it to my lord's officer, Milord, and to whom them, if it is paid, they will accept because they went to
Lordship,
Ministry of
if
Law.
I may-
It is addressed to, it is,
To the executive engineer, Union of India, CPWD, but they have not accepted it.
Milord, we are providing it.
All right, all right, all
Because
right.
Milord, what happens is we are different departments, and this is a specific department.
then they have to make a fresh demand draft. They have
No, not remand, it's a check, your lordship.
to check.
Yes, lordship,
Check they can, it
One-
is issue in the name of
lordship,
the
there's a limitation of 3 weeks.
session that can
be
be extended
extended.
because this, for this, what was the date fixed?
Milord,
3
the-
weeks from
the
1st
matter was
September.
served-
How much time?
কোথায় order-টা কোথায়?
It is still there, Milord, because
3
3
weeks
weeks time
is
is
there.
21st, Lordship, I suppose.
Time 21st.
Because Milord, the order is dated 1st of September.
Yes,
Now,
sir.
Milord, it was served because the order says, Milord, from the date it is served. So, Milord, even if it is served on 1st, then also they have time till 21st. And since they are giving a check, Milord, I don't think so there is any, because we are today on the 16th.
Yes.
16, so you have time.
Let
Mr.
it be
Trivedi, please,
extended by a
inform-
week.
My lord, they have to send it to Nizam Palace, not a very far away place.
But you
My
can, Mr. Trivedi, can you not accept that?
My lord, no, my lord, because it's a specific.
You are for the Union of India. You can
My lord,
accept.
that is the biggest problem. What happens, my lord, there we have to make. My lord, will that is.
Otherwise, Mr. Trivedi, I tell you what will happen. That department will say, no, I am not a party. He's
No,
not a
we have
party.
taken
Union of India.
My lord,
That
we have
might be a
taken.
problem. You can accept that and
My
forward to the
My
appropriate.
lord, my lord, my lord, we have already spoken to them. They have sent the address. Just that check be issued in that particular office, my lord, and they will
So
accept
I'm
it.
keeping it tomorrow.
Lordship, let it be recorded in the order itself
He-
that it has to
He's
be
giving
paid.
the
My lord, will
name.
kindly keep it on
Giving the
Friday
name.
morning.
So you are giving the check. Please
Yes,
bring
sir.
the check tomorrow. I will record that.
All right.
Kindly keep it on Friday morning. I will ask the officer to be here.
Why?
My lord, then the
Officers
check.
have other duties, Mr. Trivedi.
My lord,
You
will
take
ki-
instructions,
my lord,
put
my
the
lord,
correct
keep it
name,
tomorrow. Lordship.
put the correct name and the designation so that they can give the check in that
We
correct
shall
name.
provide, my lord. My lord, tomorrow, my lord.
Grateful.
Mr. Trivedi. Yes, Mr. Mukherjee.
Lala, where is he? He's asking me to say something. He cannot.
Yes, Mr. Basu.
My lord, I'm appearing for the municipality, my lord. My lord, last location, my lord. My lord, my learned senior friend submitted before your lordship, my lord, that the decision was not taken by the board of councillors, my lord. And your lordship, my lord, directed the municipality, my lord, to produce the record today.
Yes.
Can you see the last one?
Yes, what is your instruction? It was passed by the
Yes, my
Board
lord.
of Councillors.
Yes, my lord.
Show me the decision of the Board of Councillors.
My lord, my lord, I have.
Civil division 27.
Yes, Mr. Basu.
Document filed in the appeal court that has to be looked into. Can you see what has been annexed? What has been produced before the court below?
My lord, those documents which are produced before the appeal court, the same documents, my lord, I am producing before your lordship. One,
They are produced before the appeal court.
yes, my lord, that is recorded in the order, my lord. And your lordship, one thing, my lord, some
All
documents.
right. All right.
Then I have nothing to say. 297 can you come?
297.
And 2 points. One is that and another is
Yes, what is the issue, Mr. Basu?
illegal construction. A person who is residing in that building, he files an application that the building should be demolished because of the illegal construction. Kalidas we have heard, now I have seen. So, so in that, order of demolition has been passed. Against that general appeal has been papered. Appeal.
You are not agree, Mr. Basu. The person who was deciding has
I am also.
along with him.
Now kindly
So
come.
he is not a regular resident of that property, but you are a regular resident of the permanent residence is yours. He is residing elsewhere.
They will go and not me.
Yes, 297. Yes.
Can you come 297?
297.
297. Of your lordship, please.
Yes.
As far as Kalibat?
Yes. What is 297?
297 is the proceedings of the order.
Yes.
Yes. Can you see the date? 31st January 2024.
Yes.
And kindly come to the order of demolition 310. 310. Extract of the proceedings. Can I read this? Extract of the proceedings. Meeting of the councillor such and such. Nowhere my lord will find the signature of any councillor. And no statement of any councillor. Whether the councillor agreed to it. And this is not a communication by the chairman. The decision of the councillor. This is the meeting, minutes of the meeting. These are the documents produced before the court. Oh, I bit told my lord 295 to 200, 300, 10, 12 is the document produced before the court below before the lower appellate court. This was the document 295 to 212.
295 to 312.
This is the document produced before the court.
So miscellaneous appeal has been disposed of. It's not against any interim order.
I don't know the final date. But I will not find my second point. If there is sketch map, which portion is in deviation?
What is the case? Without sanction plan or no sanction plan?
Deviation.
Deviation.
So deviation must be authenticated by a sketch map. Which portion is deviated? How much is deviated? Which is condonable or not? That has to be looked into. Can you see that? Can you see which portion? First is this is not the application of mine by the councillors.
Any inspection report is there?
At least from the document, I don't find.
Yes, my lord, there is an inspection report.
Show me from the,
My lord,
no, show me from the extract of this order
yes, my lord.
where it records that the inspection report was taken into consideration. Show me that.
It kindly turns to page 310.
10, my
which your
lord.
lordship is seeing. Kindly takes up the middle portion.
On the other hand, it appears
the
from
other
the
hand.
joint inspection report that the following unauthorized construction in deviation of the sanctioned building plan is apparent. Thereafter, what are those deviations that has been stated, my lord?
That this is an extract. This is not the original.
Yes.
Then last paragraph. In view of that, the Board of Councillors is satisfied that unauthorized construction has been carried on in the premises number so and so in deviation of the sanctioned building plan, and thereby the owners of the land are directed to demolish such unauthorized construction within 15 days. Such unauthorized construction, the unauthorized construction has been mentioned. Now sanctioned area is 559.20 square meter. The total area of construction is 785 square meter. Unauthorized portion from first floor to fourth floor, it has been mentioned. 646.80 square meter. Then area construction is calculated below 138.701 square meter. Everything is mentioned.
Mr. Basu, you appeared before the Board of Councillors for hearing.
Yes.
Yes, my lord.
Yes.
So prior to that, you were provided with the joint inspection report.
Yes, my
It is
lord.
one of my case. It is one of my case. Joint inspection report they were produced.
Show me that you took that point before the.
I have asked my junior to take this point. Probably has taken note.
Where have you taken that point?
This has been mentioned.
But Mr. Basu, when you appeared before the Board of Councillors, from at that point of time, you ought to have raised that I have not been served with the copy of the joint inspection report. Show me from the order of the Board of Councillors that you have raised that
This
objection.
is not the order of Board of Council. This is not the order of Board of Council. They are saying will do.
No, you have raised that point before the Board of Councillors. Show me where have you stated that.
Probably I have taken the point in the appeal.
Show me where appeal memorandum of stay application is annexed here.
It has to be taken by the. Admittedly, it has not been served.
No, not admittedly, Mr. Basu. How can you say admittedly? Show me that you have taken that point. Mr. Basu, the first thing, when you appeared before the Board of Councillors, you ought to have taken that
I
point.
am saying Board of Council has not applied this point.
That's a different thing altogether. First thing is that
Not the meeting of the Board of Councillors.
that I will consider. But first thing is whether you have taken, because inspection was made, was that inspection in your presence or in your absence? First. Second.
At the page 288, the joint inspection, the petitioner has signed, promoter, Shobhu Mollik.
Report.
There are, yes, first is whether inspection was made in your presence.
Yes, signed.
First. Second is, even if it was made in your presence, whether prior to the hearing before the Board of Councillors, you are given the copy of such report. Second. Third is how that order was passed. I will look into that. But first, show me that you have taken that point that it was not served upon you prior to the hearing of the Board of Councillors.
And another point I am discussing.
Yes.
What
There
is
have been kind of plans. Without inspection,
it has to be a sketch map of demolition. Without the sketch map of demolition, your lordship could have time without number deprecated, you cannot do.
Mr. Basu, you ought to have raised these points there.
Of law.
What question of law? So, Mr. Basu will appear at the meeting, hearing will not take all those points. All in the 227, not before also in the miscellaneous appeal or the municipal appeal under 218. It's a statutory appeal, Mr. Basu.
আমাদের বইটা বলতে না না এটা মানে
Your Lordship got categorically said without the sketch map or demolition, you cannot demolish.
this is the municipal.
Yeah.
Municipal Act নেই আমাদের কাছে তাহলে দিন Municipal Act.
One point, councillor has not applied his mind, is supported by the judgment of your Lordship court. Second point, the inspection report not been sub-relied. Not been sub-relied. Second.
That Mr. Basu, what were you doing at the time of hearing? With your closed eyes? What was the purpose of hearing, Mr. Basu? You will go, attend, come back, take all points subsequently.
My lord, I have not taken this point. The fact is, which is no new fact, whether it is given to me or not on record. If I can demonstrate it has not been served.
Yes, madam. Have you served the copy of the inspection report to them, to the parties, not to them only?
A46, A46.
Only 46.
46.
Oh, A40. What is A?
A46.
এটা আবার কোথায় পাবো? What is A46? Where? Oh, yes, I've got A43. I've got A46. Yes.
13. That your appellant states that neither the alleged inspection team, nor the board of councillor, nor the council chairman ever supplied the alleged inspection report.
Yes. Have you served the copy of the inspection report?
My lord, it is admitted, my lord, that the inspection report has not been submitted to the parties, my lord. But your lordship kindly consider, my lord.
How can a party?
My lord, your
How can a party contradict the inspection report which has not been served upon such?
the petitioners and my lord, the private respondents, they were present at the time of inspection, my lord.
Maybe.
My lord, at that point of time, they have not.
You are suggesting if you are present, an order is passed in your presence, so you don't need the copy for preferring challenging that order.
My lord, they have not asked for.
You are required to serve them a copy.
My lord, your lordship kindly see, my lord, when the order was.
Show me the
communicated-
inspection report. Where is the sketch plan? Demolition sketch plan. Show me.
My lord, it has.
Because madam, here the entire building is not an unauthorized construction. It's not a case that a construction has been made without any sanction plan.
There
It's
is
a
some
case of deviation.
Yes.
Show me how have you identified those deviations.
My lord,
Show me.
My lord, the engineers of the municipality have measured.
Show me from the report.
My lord. My lord.
Show me
your
from the
lordship
report.
kindly-
288,
It has also been annexed in the.
Which page?
288, 89.
Yes.
288.
Yes. 288 the inspection, where serial number 5 is the promoter. He has signed. Then
My lord, your lordship,
289.
289, your lordship, can
On
you see the
inspection and measurement.
inspections? On inspection, we found that there are unauthorized construction. Before that, my lord, joint inspection and measurement report of premises number such and such. On inspection, we found that there are unauthorized constructions at the above building.
Madam, if I ask you to demolish the unauthorized construction today, can you demolish? Can you identify and demolish?
My lord, I'm
Show me
reading.
the plan.
My lord, I'm reading. My lord, from the inspection report itself, it can be identified, my lord.
How?
My lord, your lordship.
Without any plan.
Plan is 291.
291.
Yes, 291, 292, 293.
No, this is the site plan. Where is the demolition sketch plan?
Something else.
Where is the demolition sketch plan? This is the plan. Oh, no. Projections have been given.
Yes, my lord.
Yes, Mr. Basu. 293 projections have been given.
290.
Yes. Dotted lines.
Yes, my lord.
Those are the projections. Page 293,
Yes, my lord.
the second part.
Yes.
Yes, so projections have been given, unauthorized part, projected from first floor, those dotted lines. The internal is the plan and the dotted lines are the projections.
Right, my lord. Now, my lord, kindly compare this. Let us compare it with the report, with the demolition order.
Yes, so those are all facts, Mr. Basu. So these you have annexed. These were with you. You did not raise these points.
Yes.
Yes, this demolition sketch plan, this
At the time of appeal, they relied on. This is not my case.
no, it was,
Appeal, not before the demolition order.
yes, in the municipal appeal, you have got that.
Where is this point?
Show me in the impugned.
The point not be served upon me.
Yes, yes. Show me in the municipal appeal this point we have raised
I've said paragraph 13
of the.
municipal appeal. Just now I've shown 46.
No.
Not
At
this
the-
stuff. This
Yes,
document.
yes, I take it because she has also admitted that it has not been served.
This document is not been served. How can I take this point? I'm asking the question to myself.
No, in the municipal appeal, prior to the hearing of the municipal, I'm not on the before the municipality. In the municipal appeal, prior to the hearing of the municipal appeal, you are served with this copy. You had this copy. Yes.
This copy of never served.
Mr. Basu, this was given. You have annexed this.
How
I have
it has been annexed?
Mr. Basu, I'm not saying before the board of councillors. I'm saying before the municipal appeal, before the.
Municipal appeal.
Yes, I'm saying that you are not hearing me. That's the problem. I've said, I'm repeatedly saying municipal appeal.
The municipal appeal because the code below.
Yes.
This document was.
Code below now cannot be used, that expression. So that is why I'm repeatedly saying municipal appeal. You are saying I've taken that point. Municipal appeal, show me before the learned judge, you have taken this point. How have you dealt with this?
46, eh?
At the time of hearing.
Whatever point I have taken this the point of hearing.
So Basu, you may take 10 points, 12 points in your memorandum of appeal, stay application, but you may choose to make your yes. Show me.
I have taken this point.
Maybe you have taken. Show me that you have raised that point. Issue.
Yeah, paragraph 30. Raising the point.
Pressing.
Sir, raising the point is paragraph 30.
Pressing.
Raising, my lord.
I correct myself. Pressing. Issues not pressed, abandoned. Issues not pressed, Mr. Basu, abandoned. So I correct myself, not raising, pressing.
It was pressed, not recorded. What can be done?
Then go there.
Go there.
Yes.
They have to check it whether this point has been taken or not. Very short, my lord.
But the Xerox copy or the, I should not say the Xerox copy, the certified copy is not also very legible. The impression which has come, your copy is legible, Mr. Basu.
Can be. The certified copy of the order improved.
You have made a copy from this or you have a different copy, Mr. Basu?
I made a copy from this.
From this? Please see my copy. From this, that copy will be.
How the victims can accept that?
Yes, Mr. Basu. Go through that. Come tomorrow.
Can you see here? It is the point further that the joint.
Where? Which page?
Can be transferred.
Which page?
The page 5.
Internal page 5. Yes.
Court has said, thus this court.
Yes.
Court is bounded to the fact that the applicant was given sufficient opportunity to present the case or not. The result of the entire municipal proceedings. Record is transferred that the landowners authorizing of respondent number 6 Newton and part from different copies to appear to the municipality present their case. Further, from the joint inspection report, it clearly transfer appellant and such present before the. So kindly read this. So this point was raised vis-a-vis paragraph 13 of paragraph 6, page 46A. Court relied constitutional report which admittedly have said not served.
Why don't you serve the inspection report? Why don't you serve the inspection report? How the parties will appear before the authorities without the inspection? That's the basic. Where is that decision, Mr. Basu?
My lord, at the time of hearing also, my lord, they have not asked.
Maybe.
Your lordship kind.
Violation of the principles of natural justice with the inspection.
After
With the inspection report, I am remanding to the.
my lord, your lordship kindly consider, my lord, after getting the inspection report, my lord, in the municipal appeal, my lord, that point has not been placed also before the.
What?
For the,
But the madam is initial order is by the Board of Councillors. If the initial order is by the Board of Councillors, unless they get an opportunity, there is a violation of the principles of natural justice. Why are you not supplying the copy of the inspection report? This relies upon that Justice Rumapal's judgment.
So this is not on service matter. This is for the sketch map or demolition sketch map.
Sketch map.
No, I am on that. No.
This is service jurisprudence.
Yes, not SAR. No. Justice Pal's judgment is also on Municipal Act.
So prior to that, our service matter judgment is
Yes,
there.
that is there.
It says that if you rely on a document, you have to serve. What may be the consequences?
So here the sketch plan was also not given. Supply of presses as well as the demolition.
And probably, my lord, subject to correction, up till now, my lord, probably my lord is not satisfied that the councillors has applied the judgment. Not for my lord staying there. The councillor has to apply their mind. Statute says.
Show me the
Councillor
original order of the.
applied, my lord. I'm submitting, my lord. Your lordship kindly see, my lord, after my lord inspection, my lord, your lordship kindly consider the minutes of the meeting of 31st January 2024 that was placed before the Board of Councillors, my lord. And
With
that
original order, this is only the extract copy communicated by the chairman.
my lord, I have brought the record.
Show
my lord,
me
all
that.
the proceedings of the Board of Councillors are there.
Can you read once again?
My lord,
That signed by the chairman only.
I'm
the
saying so. Mr. Basu, there are two things. The original resolution, all right. Please let me see the.
This is
my lord, your lordship
Yes,
kindly
show me
consider,
the
my lord.
original resolution.
There may be one attendance register, attendance sheet, nothing else.
Mr. Basu is so confident. These are all internal documents of the
I know, I have sometimes appeared for the municipality also, I know.
My lord, your lordship kindly see 31st minutes of the meeting dated 31st July 2024, serial number 18.
97. My lord is looking at 31st January's minute.
This is not the records, madam. This is the Xerox copy of the records.
My lord,
This is the records. This is a Xerox copy of the records. All seal of the chairman.
why I am submitting, my lord? My lord, the same records, my lord, was produced before the
So where is the resolution by the Board of Councillors, madam?
your lordship kindly.
Please find it out. Not the extract which is annexed here.
My lord, I have annexed, my lord.
97. This is document produced before the court below. My lord, will not be find anything excepting name of the councillors appended there, nothing else, no signature, nothing.
My lord, I am
Far
showing
less to speak of any application of mine.
my lord, I am showing the signature, my lord. Your lordship kindly see that is
What
the
document was produced before the court
proceedings of
below?
the meeting 31st January 2020,
Give me that.
2024. My lord, your lordship kindly see the agenda of serial number 8, my lord. My lord, that matter.
Show me the signature of the Board of Councillors.
Oh, that should not be afterthought.
My lord, not afterthought. My lord, I am saying what happened.
The Basu, she is a junior member of the board. These comments will distract her.
My lord, here, my lord, the signature of the Board of Council.
Yes, you are led by Mr. Rai.
Yes, my
Where is Mr. Rai?
lord, he is in, my lord.
Circuit bench.
My lord, the circuit bench is not there, is not there, my lord, but due to some difficulties, my lord, he is in.
Yes, yes.
Before, my lord, placing the record, I am submitting one thing, my lord. Same records were produced before the.
Show me, madam, show me the signature of the Board of.
In the 31st January 2024 proceedings, the signature page is not there. Why? Because, my lord,
What subsequent event?
Your Lordship kindly consider, my lord, in that proceedings, my lord, decision was not taken. In 31st January, the agenda was placed before the Board of Councillors.
When Mr. Rai will be available?
Can you record this? Otherwise, there will be difficulty.
Says Mr.
She is saying, can you record that?
28
From
February.
this, but this is Mr. Basu, this is not the original records. This is not the original records.
The Xerox copy signature will also happen there.
No, this is this. If
If subsequently
please,
something happened, I'm
have you
giving
seen this? This is the only copy which is annexed here. So this is the copy which has been annexed here. Nothing more than that. Yes, when Mr. Rai will be available?
My lord, next Tuesday.
Next Tuesday. Then after vacation.
After vacation.
Or one thing, I can remand it to the Board of Councillors. I think that's better. I think that's better. You serve them a copy.
If there is any deviation, to control it, law permits. Law permits. Law permits.
Mr. Basu, for that you have to take steps. There is a regulation, rules, circular also.
Yes, it has come. On that date, it was not there.
So don't, you are at liberty because I am remanding that.
It is not, my lord, not given hints. I cannot even apply.
Why? Mr. Basu, if you are entitled, yes.
I will make that.
At least,
344 minus 344 I notified.
anyone, keep any, he is aware of the facts.
344 can you once look? 344. 344. That circular I have annexed to get the benefit of that.
A34.
334.
Oh,
344.
you have given A. This, what is A?
344.
What is A?
G will. Super. 344 will tally.
Mr. Basu, nowadays you have also started annexing the copies of the judgments in a civil division application.
It should have been given to Mr. Mukherjee so that he can get slapped. We will also get. I'm blaming to me. I have take the blame. Certainly. 344 kindly come. This is the circular now holding the field. Kindly allow me, if I am entitled in law, I can take the benefit of this circular. Nothing more.
Then, Mr. Basu, you are admitting these minor deviations.
How can I deny it? Minor deviation is there. I have no hesitation to say there is a deviation. I don't record that. If it is found ultimately it's deviated, so that I can take advantage of this circular.
This application under Article
in record of the in the municipal appeal. Your lordship kindly, my lord, observe that, my lord.
No, that original records you must be having copy, madam. You have not produced copies of also that original containing the signatures.
Whatever they produced there, we all annex it.
From that, this is the record which is lying there. Here the signatures are not there. আচ্ছা এটা লিখে নিয়েছেন তো কপি Yes, call the next matter. Yes, Mr. Rai.
Father is the petitioner before your lordship. Father is the petitioner before your lordship.
Visitation right.
Now let's 25th is the date of birth, 10th date of birth. Malan, the child is residing with the mother at Uti, and now I am at Bombay. Now if your lordship
Child residing at
Uti.
Child residing at Uti.
Yes.
How this proceeding is here?
Because Malan, the original suit has been filed here. Now she's the child is residing with her mother.
Mother is in Uti. You are in Bombay.
Yes.
Suit is Shialda.
Shialda. Now kindly come to page 90.
Sir, how this?
Kindly come to page 90.
90.
90. This is the order on the last occasion. It was with regard to the visitation. This order was passed by this honorable court on 24th September 2024. Page 90. Have you not
Yes,
got it?
yes.
Now the kindly come to page 91.
Yes.
Second paragraph.
Yes.
The parties after much deliberation through their respective learned advocates have agreed to the following arrangements for the access to of the father to his son. On September 24th, the mother shall bring the son.
This is the birthday. 25th is the birthday.
25th is the birthday.
So you want a similar order?
I want a similar order.
What has been done? Rejected?
No, this was posted for hearing on 19th. The original application has not yet been taken up for hearing, although there is a direction. The wife is, the mother is taking, I should not say wife, the mother is taking time. Once this was fixed for hearing.
You have filed an application.
I filed an application that is at page 93.
93.
My lord.
What is your prayer?
Kindly come to
Consider
prayer.
as the next birthday.
94, page 94.
Yes.
It is therefore prayed that your honor may graciously be pleased to consider 25th as the next date of birthday of the instead of 25th for rendering passing considerable order.
Mr. Rai, is it a happily couched prayer?
But it has not been couched in that manner because
For rendering possible considerable order.
Because this application was probably
cut copy paste. Only the date has been.
Yes. Now since this earlier the order was passed.
How can this be passed? Order be passed in the absence of the other side, Mr.
Well,
Rai?
that's the problem. One thing I can do,
No caveat has been lodged.
No caveat has been lodged. I can serve a copy and come because 19th, I'm frank.
5th, Mr.
19th is the date fixed. I can wait and see what order is passed on 19th. If no order is passed or it is adjourned, I can agitate that before your lordship on the next.
I can do one thing. I can direct the learned trial judge to dispose of that application on 19th, and I can give you liberty to refer to this order at the time of hearing. I think that's the
my lord.
Best which can be done.
Without granting any adjournments. Because 25th is the date and 19th is the date fixed for hearing.
Because in that application, that is the only prayer.
Yes. And I shall also pray before your lordship, since the original proceedings, the 38 application has not been proceeded any further because after filing of the objection, the mother is not
expeditious hearing of that.
Yes, expeditious hearing of
the right. Now it will be difficult. If I pass that, then I cannot say it.
Very well. Then on 19, let us restrain our prayer with regard to the 19.
What is the order you have challenged? August 12,
My lord,
2025?
kindly come to, my lord, the last page.
It was fixed on that date.
Yes.
Why show cause?
Show cause because, my lord, the mother didn't appear when the application was fixed for hearing. 4th June, I have filed this application.
Ashwin. This application under Article 227 of the Constitution না তার আগে না এই একটা প্যারাগ্রাফ একটু অ্যাড করে
Number two was decreed ex parte on 20th.
Decreed ex parte.
Decreed ex parte. Preliminary decree was passed.
You are the
plaintiff. Preliminary decree was passed on 20th February 2018.
Yes, what is the order impugned?
Now what happened, my lord? Number I filed an application, but don't go through the order.
Why?
Because my there are some. I filed an application on order 26, rule 13. But after the over of 3 months, that was filed in 2019. Now the learned judge initially record was misplaced. Subsequently, when the record traced out, the court is of the opinion decree cannot be passed without the presence of the other side. But my application is for only. But kindly see two order. I will show to your lordship. The court is of the opinion that this decree cannot be passed without the presence of the other side. This is not a decree. This is an application for appointment of a survey pass commissioner. But kindly see the order number 13 dated. Order dated 13th August 2024.
13th or 14th?
13th August, 13/8/2024.
2024.
2024. This is number one. The court, this is an application for appointment of commissioner. Survey commissioner will go. They are not interested to come, but they are not receiving the summons. But since 2019, this application is still pending. This is the application under order 26 rule 13 for appointment of a survey pass commissioner. Kindly see my prayer in the application.
When the decree was passed?
2018. Kindly see once order 26 rule 13 once. Everyone's share has been declared.
But Mr. Mukherjee, you have served upon some.
Now
What's the difficulty?
Now I'm telling you, Lordship. Now the date is given after 5 months.
Addressed to the correct persons.
But they are residing. They are avoiding the summons. That was.
But that is not to the correct persons.
But correct person. I have served in terms of the defendant's address. But
not the correct person, not the correct address. It
That's
has
why
already said that.
That's why I'm challenging the entire order sheet. The order because
But
what
you have accepted a part of the order.
No, I have not.
Because yes, service summons upon the others.
I put now why I'm your lordship knows order 26 rule 13. This cannot be a decree. Kindly see, final decree cannot be passed without the hearing of the other side. But this observation kindly visualize. But I am more. My client is suffering with brain stroke. He is more than 8.
Mr. Mukherjee, one thing, maybe the preliminary decree, maybe the preliminary decree has been passed ex parte. Are the parties entitled? He has declared. So are they not entitled to an hearing in the final degree proceedings?
Obviously, but this is not the final degree. I filed.
Starts with the appointment of the commissioner.
I filed an application for my appointment of survey pass.
The appointment is the starting of the final degree proceedings.
But kindly visualize, if you see once order 26 rule 13.
Yes.
But your lordship has possibly seen by this time. But now the question will come if the commissioner done the commission work ex parte, then the question arises setting aside the final degree.
What is the step? Please serve upon these opposite parties. Let
But
them
they will never come. May I pay only one thing? But this applicant has to be disposed of within certain time. Kindly make that up.
That I can.
Kindly do. But what?
Application under article. This application under article.
But it is not required to serve.
Lord, I appear for the petitioner, my lord. This is an application for expeditious disposal.
Of what?
Of an application for dismissal of the suit, which has been filed
Application
on,
for dismissal of the suit
of the suit, my
or
lord.
rejection of the plaint.
A dismissal of the suit, my lord. Which was filed on 23rd.
On what ground dismissal you have paid for?
My lord, the ground is.
Order 7 Rule 11.
No, my lord. That is filed by the other. Order 7 Rule 11 has been filed by the pro forma defendant.
Order 7 Rule 11, Order 14 Rule 2.
Yes, that is filed by the defendants. And I am the defendant number 5, who is the added defendant. My application was filed much previous.
Installments you are paying.
No, my lord.
Some of the defendants, Order 7 Rule 11, some Order 14 Rule 2, some dismissal of the suit.
I have been added, my lord. What has happened, my lord?
This application under Article 227 of the Constitution of India is at the instance of
I beg to appear on petitioner, my lord.
Yes.
Defendant in a suit for eviction.
Yes.
And what has happened in this suit is, my lord, the plaintiff contended that a notice for eviction was served upon us. In the written statement, I have clearly denied that no notice was served upon the defendant. My lord,
no summons served.
No notice for eviction was served.
Oh, yes.
Notice being the foundation of the suit.
Yes.
Now, what has happened, my lord, at the time of trial, the said notice for eviction was not tendered as an exhibit or as for evidence. Neither a photocopy of that said notice was tendered for evidence. Now, at the argument stage, the plaintiff takes a specious plea that he has lost the original notice and he wants to, by way of a recall of the plaintiff, wants to bring on record the photocopy of the said notice. But that is not permissible.
If the foundation can be laid for leading secondary evidence, Mr. Dev, where is the difficulty?
Kindly appreciate. Had he put those evidence at the time of giving evidence, there was no difficulty. But he has.
Then there was no necessity for recalling. Recalling is if some documents were or some evidence could not be laid at the appropriate point of time.
Nothing.
And the same.
Nothing was
that if it is necessary for the purpose of.
Lordship, kindly appreciate.
This is the very basic foundation of the suit.
Lordship, kindly also appreciate he is now trying to improve his case. He is now trying to fill up the lacuna.
That is one way of looking at it. Other way is if it is necessary for the purpose of administering justice.
Lordship, kindly sees the order itself. The order is very clear about it. Lordship, kindly comes.
2009 4 SCC is in your favor, but 2011 11 SCC is against.
Now, Lordship, kindly sees it. Lordship, kindly appreciate. At the time of argument, he discovers that it was not laid. Now, he takes a specious plea. He could have taken the straight way. He could have said that it was not done. He says that he has lost it. So, therefore, he wants to bring it on record. He goes by the indirect way.
But, yes, Mr. Dev, the fact remains.
It's nothing but
that document is a relevant document for the purpose of deciding the suit.
Lordship, kindly appreciate, Lordship, had it been the original, things would have been different. He's not going to bring on record the original. He's trying to bring on record a photocopy of it.
To that, Mr. Dev, you can object to that unless the foundation for leading, that's a secondary evidence. If the secondary evidence foundation is not laid, he cannot be permitted to lead secondary
Lordship, kindly
evidence.
sees the finding that Planet Court says it's a fault on the part of the plaintiff and it is not
Has been allowed.
Yes, he has allowed it, but Lord kindly sees the finding. Fifth line. It is at the argument stage. Learned advocate for the plaintiffs. My lord has got it.
Yes, I've seen one line, that is the,
Learned advocate for the plaintiffs.
Mr. They have
in
seen,
the course of
the
argument.
reasoning is there.
Now Lordship kindly comes to the reasoning part.
Yes.
The penalty.
Here in the middle,
Keeping in mind.
admittedly, it appears that there has been negligence.
No, Lordship,
Says-
before that. Keeping in mind the submissions of both the parties, it appears that neither the original or copy of the notice to quit, postal receipt, signed AD card, and receipt of UCP has been filed by the plaintiffs during the course of trial. So nothing was filed during the course of trial.
Show me the application.
Yes. Lordship kindly sees page 15. Nothing is pleaded.
What
this
we are
text,
trying
nothing
to
pleaded.
introduce now, to prove and mark the documents, what are the documents?
And there is no schedule.
Original copy of the notice, postal receipt, signed AD card, and receipt is not available and not traceable, as well as in the content. Oh, Mr. Dev, it says Xerox copies have been filed along with the documents of the plaintiff.
No.
That's there.
But Lordship kindly sees the clear finding. Clear finding of the learned court below. It appears that neither the original or copy of the notice.
Did you file any objection to this application?
Yes, I filed an objection to the
Show me
application.
that you have denied that those documents are not part of the claim.
But the objection was not taken on record by the learned court below
No,
since there was
you
a
show me that you have taken that specific point that those documents were not filed along with the plaintiff.
Yes, Lordship kindly comes to para 5.
No, para 5, you said that no
That the
notice
statement
of...
made in paragraph 3 of the incident application, the defendant states and asserts that no notice to quit has ever been served upon the defendant.
Mr. Dev, where is the original plaintiff?
Where is the plaintiff? Yes.
Because you have purposely not denied that specifically. Paragraph statements in paragraph 2. How have you dealt with statements in paragraph 2? Matters of record. You have chosen not to controvert that specifically, Mr. Dev.
But Lordship kindly go by the finding of the
This
learned
application
court.
under- Thank you.
Only one thing, Lordship.
Yes.
Only one thing. Lordship kindly sees the finding of the learned court below, Lordship.
Yes.
Keeping in mind the submission of both the sides, it appears that neither the original or copy of the notice to quit, postal receipt, signed AD card, and receipt of ECP has been filed by the plaintiffs during the course of trial. At such belated stage of argument, the learned advocate for the plaintiffs discovered that the notice to quit along with annexures have not been filed by them. Admittedly, it appears that there has been negligence on behalf of the plaintiffs, but at the same time, it is also to be considered that in an eviction suit, the notice to quit is very crucial for adjudication the subject matter of the suit. Therefore, Lordship, if the plaintiff fails in its primary duty to prove its own case, my lord, he has to also suffer the consequences. Lordship, kindly seize it, my lord. Just because the plaintiff in a suit for eviction, he will not get a privileged position.
Have you got 2009 volume 4 SCC?
No, I don't have it right now.
Thank you. This application under Article 227 of the
Yes, it is not recorded, my lord. The learned court will automatically take.
No, no, no. Mr. Dev, why are you anticipating that? An evidence tender automatically it will be exhibited. What are you saying? That cannot be.
To kindly records it. Some protection to that extent.
This is the protection I have said in accordance with law. Yes. Why are you scratching your head, Mr. Kormokar?
Lord, the difficult, I know, Lord, this is not a mentioning time. Lord, today I filed a revisional application. I've just come to learn, Lord, the counterpart of my client, Lord, in Baruipur court, Lord, there will be some difficulty for your Lordship to take up the matter. Lord, I will only beseech your Lordship to, Lord, direct this matter to appear as to be mentioned so that we can get it released and get it heard somewhere else.
To be
because of the
mentioned,
urgency.
File has come. What is the date mentioned there?
Lord, day after tomorrow. But because of this problem, Lord, it's extremely urgent. Extremely urgent. I number and
Lordship.
Yes.
There was a Lordship I have served.
Who is appearing?
Krishnendu,
Krishnendu
Mr.
Be-
Krishnendu Berai. He was there here, Lordship, before the break.
He was here.
Yes, yes. He was here. Lordship, we are calling him. Right to phone call.
Yes.
Lordship, the judgment letter is the petitioner before your Lordship.
Now, Lordship, suit for eviction decreed. I have preferred an appeal. Appeal was dismissed for default. Now,
For default,
yes, my application under order
you are very diligent in prosecuting.
41 rule 19 along with section 5 is pending, Lordship. Now, Lordship, they have put the decree into execution. Now, Lordship, by filing a put up petition, Lordship, ex party, they have got an application under 151 allowed for police help, Lordship. Even a copy was not served upon me. Lordship will kindly take up the order in fume, Lordship. That is order number
25th of August.
25th of August. Order number 97, 25th of August 2025. The record is taken up by way of put-up petition filed by the decree holder through her learned advocate. Decree holder files one petition under section 151 for police help at the time of execution. Record transpires that report received from the seal bailiff duly forwarded by Nazir Civil Court Arambagh dated such and such, wherefrom it appears that execution was vehemently obstructed by judgment daters. And even the police, Lordship, I can't read my police personnel from the local PS appeared to control the situation. Let the report be kept with the record. Heard the in respect of petition considered. By filing instant petition, the decree holder specifically stated that the judgment daters and their men and agents tried to assault the process server of the court and also intimidated the decree holder with their consequences, and even police personnel from local Khanakul PS had to appear at the decretal property and to rescue the process server of the court and the decree holder. It is further submitted that the decree holder, that the concerned OC Khanakul PS assured to render police help on the next date of execution as and when they will be informed by this court. Under such circumstances, the decree holder prayed for execution through police help. Considered. After perusal of the report dated 18th of August 2025 of the seal bailiff and after perusal of the instant petition, this court is of the view that even the seal bailiff complained of a like situation at the decretal property, and hence under such circumstances, considering the assurance of the local PS, this court is inclined to allow the said application.
What can be done?
Let a copy be at least served upon me, Lordship, an opportunity be given to contest the same. Moreover, Lordship, we have not even been served.
Objection. How can you object to this if the seal bailiff is resisted by that way?
Lordship, my specific
now there is an order of stay also.
True. But today is the date, Lordship, before the appellate court, Lordship, where I shall be moving my order 41 rule 19 application. Now, Lordship, my
put up because prior to that also the seal bailiff went. That is the report of
Lordship
20th of August.
Lordship will kindly come to my petition, Lordship. I have stated that.
But this application was not served upon you.
No, nothing.
Yes, how can an order be passed?
One of the judgment debtors has died also, Lordship, on 9th.
But others are already on record.
Lordship, judgment debtors, Lordship, kindly notice that in the order it is mentioned judgment debtors and their men and agent. There were only 2 judgment debtors. So if one dies, Lordship, there is only one. Because Lordship kindly sees, Lordship,
it should be judgment debtor, not debtors. According to you, it should be judgment debtor, not debtors.
But Lordship, I should at least get an opportunity, Lordship, to go through the application. But Lordship knows AI 1975, Lordship, AI 1975, Calcutta page 33, Lordship. Under what circumstances, Lordship, an application for police help can be allowed?
Circumstances, Chakravarti, it has been.
Lordship, that is but I was not allowed to
the seal bailiff's report.
Lordship, I have nothing, Lordship. Nothing was there.
Resisted. This is the report.
What I have stated, Lordship, I have stated that. Lordship, kindly come.
Yes, what do you say?
Order, my lord, kindly.
The appeal was dismissed for default. A restoration application is pending.
2009, this appeal was filed. Still 16 years. And what is the conduct? If your lordship kindly go through this.
Where it was dismissed for default?
It was dismissed for default, my lord.
Page 32, Lordship, is the order.
and due to disgusted on the conduct of the appellant, my lord.
24, Lordship. It was dismissed on 7th of February 2024.
This order was passed. Learned advocate for the respondent is present. 13th June 2023, order of stay was vacated. They moved an application under which case, my lord.
Yes, it was dismissed on for default on
7th of February 2024, Lordship.
7th of February, and this application was with section 5 or without section?
With section 5, Lordship.
With section 5.
Section 5.
Yes.
Section 5 allowed.
No, pending.
It was dismissed, and thereafter, several opportunities have been given by the learned executing court. Today is fixed for, I have handed over, 6th September 2024. Today is fixed for adding order of MJC, HR 5 Hadira, JDR 5 petition praying for 25 W.
So, Lordship, I was contesting the
Which order you are placing?
Kindly comes to the 1, 2, 3, third page, my lord. Order dated 5th of September 2024.
5th of September, yes.
Same, my lord, order has not yet been passed in MJC. 16th of
What is MJC?
My lord,
Miss Judicial.
my lord. Date, my lord, order number 94. Today is fixed for adding order of MJC. Both sides had seen the order 5, 19th March 2025, passed in the
But why have you not served the copy of the section 151 application for police help?
My lord, that I have to take instruction, my lord.
That's
Let me come
the
back tomorrow,
that's
my
the
lord.
recording, nothing.
My lord, that I need to take instruction.
Then, Lordship, I am praying for an order of stay of the order impugned.
And your lordship, I moved an application before your lordship, my lord, for expeditious.
No,
This-
that is neither here nor there.
My lord.
You can move an application for expeditious hearing. That does not say that
No,
police help can be allowed.
And pursuant to lordship's direction, my lord, this execution proceeding has been proceeded day to day, my lord, on this. My lord has pleased to direct.
I have only directed to dispose of, but it has to be in accordance with law.
As the judgment debtor fails to bring the order of stay order.
Yes. No, there is no difficulty. I'm not saying that the executing court could not have proceeded with. But the fact remains, when an application for police help has been passed, can it be allowed ex parte?
I believe so, my lord, that has been served. But
No, Lordship, I will put up. Lordship, kindly see.
It was by a put up petition.
Yes.
And on that date, you filed an application for police help.
Yes.
my lord,
No
kindly
recording
make it
also,
possible.
Lordship.
I take instruction. Kindly make it possible for 5 minutes.
Lordship, I have also specifically on oath pleaded that it was not served upon me.
The prima facie appears from this. That put up petition was also served upon him. Yes, call the next. Yes, next.
41, I am for the petitioner, but perhaps my lord won't be taking up this matter
My lordship.
because previous occasions my lord has already released this matter.
Since I am not inclined.
The copy today on.
Since yes, Mr. Kaur.
But it's for expeditious disposal of a Section 9 application, which is pending before the City Civil Court.
You are opposing this.
My lord, I have received the brief, my lord, yesterday night at 11, my lord, by email, my lord.
God is only paying for an expeditious, director for expeditious hearing.
My lord, matter was going on, my lord.
I just explained to your lordship, Lord. Kindly see the order of 25th of April 2025 first.
25th of
April 2025. This is in the bunch of the certified copy.
Yes, 25th of April 2025.
Yes. Lord, when the date when the Section 9 application was moved ex parte.
Section 9 arbitration conciliation.
Arbitration conciliation was moved ex parte. On that day, Lord, they got an order of receiver ex parte for the purpose
Finance
of
company.
finance company for the purpose of
You are the borrower.
borrower. But there were default of 2 installments and they got the order for appointment of receiver to take possession of the assets, of the mortgage assets. Now, Lord, this was done ex parte.
What is the nature of the asset?
Assets are machine. The machines, Lord, which are printing machines. Now, Lord, the receiver came, took possession, Lord, running business, came to a halt. Now, Lord, we filed an appeal, Section 37.
Yes.
The appellate court said that you go and take your defense before the Section 9 court, file an application. So we filed an application for recalling. Now, Lord, the application for recalling, the one of the grounds.
Recalling means suppression is your ground.
No, ground twofold. First is that court has no jurisdiction. Because, Lord, under the arbitration clause, Pune is the jurisdiction. Your Lordship, I can show your Lordship, but this is the main point on which, Lord, we are fighting. And there are also, Lord, question of suppression because, Lord, the 2 installments, etc. Now, Lord, the matter was being taken.
So it is admitted that only 2 installments are left.
Yes. 2 or 3. 2 or 3.
Yes, madam, can you not take instructions? What is the amount of, if they can pay, Mr. Kaur, you cannot pay the other installment.
Yes, I am told the default has been made good in the meantime.
I have no instruction of that, my lord. May I come up with instruction, my lord? Then
Sort it out that now you want that Section 9 to be disposed.
Section 9 was being heard, Lord, by the learned judge.
Being heard.
Was being heard. My application was being heard.
Yes. Then
now,
what
Lord, the problem is that at the end of the order, your lordships will find order number 10 dated 3rd September 2025.
Yes.
After, Lord, our hearing was concluded, then, Lord, it says that the case is adjourned today, fixed 10th November 2025. So, Lord, my business is closed. I am suffering.
Mr. Kaur, preponement is a difficult.
No, Lord, I am only suggesting this, that in case your lordship is not with me on the preponement, at least, Lord, only on the opening of date of the matter.
What is the opening date?
The 27th, I think.
That is also preponing, Mr. Kaur. Either way, before or after, preponing from here may be a difficult thing. I can give you liberty, you can apply there for preponing. Because, Mr. Kaur, I do not know the business of the court. It's
Lord,
difficult.
the problem is, Lord, I am out of business.
I appreciate that. I can give you liberty from here directing a court to decide on that particular date. It's might
Lord,
create some injustice.
I appreciate, Lord. But Lord, 2 weeks.
Because all courts are hard pressed, Mr. Kaur.
I bow down to that. But Lord, after opening, this is Lord 2 weeks after opening. Kindly see, Lord, 10th November.
This, diary did not permit an earlier.
Lord, the issue is, Lord, I will not survive by the time the matter comes up.
So I give you liberty to apply for preponement any date prior to that. From here, fixing is the problem, Mr. Kaur. I cannot fix a particular date.
Lord,
that will
But the problem is that then keep the matter pending. Let me apply for preponement. In case, Lord, the court does not consider that, Lord, let me come back to your lordship.
Preponing, Mr. Kaur, it will be, even if the court says no, it cannot be preponed. 227, can it be said, you please hear it on that particular date? It's difficult, Mr. Kaur. Because
Lord,
no,
then kindly do this. In case, Lord, preponement is not, Lord, considered, at least, Lord, on 10th November.
Yes, yes, that I can.
And Lord, day to day, if possible, Lord, the matter should
That
be
I
heard.
can-
Lord,
that
I can show your lordship the arbitration clause. Lord,
that I can provide that on that date to be taken up. What is your arguments is over.
My argument is over. And Lord,
it's only they who have to make
yes,
their submission.
yes.
No, your any argument is left or you have concluded?
It's concluded. Concluded. So.
So I can direct that how much time it will take for arguments?
The order records that we had to file one judgment only. Your lordship kindly sees
So, Mr. Kaur, can you not serve them that judgment?
Yes, yes, of course.
Prior to the next date, so that they can come ready with that. Otherwise, on that day they will say that this.
We'll do that. We'll do that. We'll do that. We'll give them the judgment that we want to rely on.
Appeal court orders records that the receiver could not locate the machinery.
That's on merit. I am not on the merit.
The main machinery has been taken away. What she can't do?
10th of November is the date fixed for filing of the judgment.
Kindly see before that.
And hearing of the.
He intends to file another judgment of the Honorable Supreme Court of India and submitted that this court has no jurisdiction to entertain the application.
So I'm recording that he will be supplying when. Please do this before.
By tomorrow.
In course of this week, I am saying.
Yes, yes. Yes. Lord, pass this order tomorrow. Let me see, Lord, what is the interest component if I can do something, because the assets are lying with the receiver. Receiver can give it back. And Lord, then we can do the business at least during this period. And then we can.
That's the option. You can give the calculation.
My lord, it was served, my lord, at 11:35 yesterday night.
What? This application? Sir, yes.
Some time to
This
take.
is only, sir, this is only this type of applications. Orders are passed ex parte. So for that, because Mr. Kaur's prayer is that on that date or preponement, I've said what's the difficulty. Now his prayer is that on that date. For that, you may not be any difficulty with regard to that. What is the other suggestion which Mr. Kaur that actually fell from me that he had took up that point? So it's a he says default of 1, 2 or 3 installments. Together might be some interest component also. You are charging some interest on that. So give your calculation to Mr. Kaur. Can you give it in course of this day? Because your calculations are ready.
Most of the date will be difficult, my lord.
Why?
My lord, kindly give me 2 days time. I will give the calculation.
Keep it on, Lord.
Doing this. If that is, I am also recording your submissions. If they do it, you can make a approach there.
Kindly keep it on Thursday. Today is Tuesday. Keep it on Thursday as to be mentioned. Lordship may pass the order. Sign it on Thursday. I have no objection. Lord, this opportunity I don't want to miss. I tell you, Lordship, very frankly. If only the interest component, because I'm told
that's the dispute. That no use fighting it out.
Absolutely, absolutely. And Lord, why stop my business for that? I will.
After all, since you have purchased those with finance, you have to also pay. You cannot say, I will not pay.
Of course, of course. And I bow down to what fell from my lord. Pass the order, kindly sign it on Thursday, keep it as to be mentioned. And Lord, also give me a liberty to mention the matter for the purpose of preponing if the learned court feels that.
So I'm keeping it on Thursday. I'm not passing the formal orders now. I'm recording your submission.
Yes, madam.
Shall I record that with regard to this dues or it will prejudice either of your rights there?
Dues of?
Dues if you are willing to repay.
Lord, this is without prejudice to my rights of contention that, Lord, the court had no jurisdiction to pass the order. Your Lordship can, because, Lord, I have to think about saving my client also.
Mr. Call on senior counsel appearing for the petitioner submits that though so that he will also take some time to take instructions from his client. After all, if you get the money, it can be solved.
Watch it.
Yes.
Yes, my Lord. I am appearing for the petitioner, my Lord. This, my Lord, revisional application has been filed, my Lord, praying for a direction upon the learned judge, second bench, Presidency, Mall Judges Court, Calcutta, for expeditious disposal of pending ejectment execution case number 94 of 2024. That was arisen out of ejectment suit number 237 of 2009. Well, facts of this case is this, my Lord, the petitioner filed an ejectment suit in the year 2009. Thereafter, my Lord, in 2017, a judgment and decree was passed. Thereafter, my Lord, they preferred that was passed in favor of the plaintiff for eviction within 90 days. Then, my Lord, after some time, they filed an appeal. In the appeal, that was remanded on 2 points. Issue number 6 and 7. That was also, my Lord, decided. That was decided, my Lord, on.
What is the 151 application for?
151
For hearing of the defendant on 15th of September 2020.
The 2008 thereafter was passed. The bill went to take position.
Sir, please kindly come to the order dated 7th of August 2025.
7th August.
Last page. 151 application is fixed on 15th of September 2025.
My Lord, we filed an application under 208 of civil rules. Thereafter, my Lord, they wanted to file objection. For that matter, my Lord, they filed an application.
151 application
filed by judgment debtor, my Lord.
For what?
Petition.
This application under Article 227 of the Constitution of India is
My lord, I am appearing on behalf of the petitioner.
Yes. Yes, what is the order impugned? Who are you?
It is a totally unauthorized construction, illegal construction. Already Honorable High Court even passed the order, but the opposite party didn't follow and the municipality also didn't any steps according this Honorable High Court single bench division bench order.
You are the complainant.
Yes.
So what happened on 4th of August 2025? Was fixed for hearing of the municipal appeal.
Yes.
So I'm directing the municipal appeal to be disposed of.
Yes.
The petitioner yes.
I beg to appear. The petitioner, my lord, I am the defendant number one. My lord, my application, my lord, for speedy disposal, my urgency, my lord, I am just,
What
my
is
lord,
the speedy disposal of what?
my lord, the suit for declaration and my lord, permanent injunction. I am the defendant number one. My lord, may I just submit my urgency, my lord?
2023 suit.
My lord, why, my lord, my urgency, my lord? The defendant number one, along with his wife, my lord, purchased my lord, the land, my lord. My lord, page number 11. And thereafter, my lord, the name has been, my lord, mutated in the municipality mutation, my lord, page number 27, my lord.
Yes.
And my lord, 29, my lord, there is a BLR.
What is the urgency?
My lord, may I, my lord? And my lord, 31, my lord, I have applied for plan, my lord, and my lord, sanctioned plan has been made in page number 31. Kindly appreciate, my lord.
Yes, yes.
And thereafter, my lord, the plaintiff is completely outsider, having no any right title interest. My lord, made my lord the brutally assault injury report, my lord, 32 page number. I have made a complaint, my lord, in 34, and now
police in action.
And now, no, my lord, no, my lord. Thereafter, filed that plaintiff, my lord, filed a title suit just to create a confusion that I could not, my lord, raise my ruling. Because my lord, my lord, suit has been filed, e-sanction has been rejected. Now at this stage, my lord, the next date is fixed for cross-examination of the PW1. So that is why, my lord, I am praying for as early as possible. Otherwise, my lord, I cannot, my lord. The building permit is very short time, my lord.
This application under
That-
Article 227 of the Constitution.
Milord, it is a succession case pending before the.
What do you want?
Milord, expeditiously by the charge court as the.
By the charge court, it cannot be done.
Milord, this said judge has went for maternity leave. For she will be returning after 1 year, Milord. Milord, already all evidence is completed, argument completed. Milord, kindly see the order dated to 21/8 of the to 25. Learned PO is on leave on medical ground. Judicial Magistrate First Court Uluberia is in charge.
Judicial Magistrate?
Yes, Milord. For that's why for 1 year we have to wait, Milord. Since
or you can apply for transfer.
Milord,
You can apply before the district judge for transfer.
There is only one civil judge in
You can apply before the district judge for transfer. That I can permit.
Milord,
so withdraw this, file an application for transfer.
Milord, kindly give it the direction, Milord.
This application.
His accommodation on behalf of Mr. Saurabh Prashanjam Mukherjee, advocate for the petition. He couldn't come to the court because he has his father's Shraddha ceremony.
So I'm keeping it after the vacation.
Okay.
As paid for by the learned advocate for the petition list this matter. Yes.
My lord, item number 48, I'm praying for a short passover, my lord. Mr. Arun Banerjee is engaged in another court.
Sir.
Mr. Arun Banerjee is preparing.
Lord,
Who is appearing? He was here, I think 5-7 minutes before.
Matter going on. What number 17? Matter.
Yes, Mr. Chatterjee.
I have a little bit of urgency, but I never oppose a prayer for adjournment. If your lordship passes it over, my lord, I will wait. But there is urgency, my lord, I will have to, my lord, place my matter.
When can Mr. Kaur and Mr. Banerjee? Where is Mr. Arun Banerjee?
My lord, Mr. Banerjee is with
Is,
So he is with you. Where is Mr. Kaur?
For court number 17, he is
When he can come? 4.
4, my lord, the matter it will take a little bit of time.
How much time it will take?
But very simple if it's.
But you will make it complicated.
No, I want to make it simpler.
If you say that it's simple
I
and
am
you are
saying,
saying
Lord,
that
if I am in possession, I am entitled to an injunction. That's it.
that's the most difficult thing to decide, Mr. Chatterjee.
That is the admitted fact.
Even then you have lost.
Even then I've lost both courts.
Yes. So
that's why I said
that's
that
a
I'm
good
making it
reason
the simplest
to
thing.
keep
we
it
have.
after the vacation.
No, in the meantime, they'll throw me out.
You are not in position. There's no question of throwing.
I am admittedly in possession.
But both the courts did not recognize
No,
that
they did
fact.
not even get into that aspect. I will show from the document, from the written statement that I am.
My lord, may I, my lord, I appear for the opposite party number 5.